When it comes to leaving distribution to family members, I would say probably 99% of our clients, if they're leaving money to family members, if they have children, if they're leaving money to kids, they typically just say, hey, I want to leave everything equal to them. 50-50, one third, one third, one third, whatever the case it is. They might say, we'll leave some money for our grandkids or something, or maybe a church, a charity, a cause that they have. But typically it's to the surviving spouse after they pass away, and then everything equally to their kids, which is great. But then we get into conversation about how they want to leave it to the kids. And that's where things get a little bit more interesting. Sometimes it's difficult conversations. Often it's things that, they hadn't even thought about. For example, they think, oh, well, when we pass, we just want them to get the money. Depending on their ages, if they're under the age of 18, obviously we can't just leave money to a minor child. So it has to be set up in trust or something for them. And depending on the amounts, typically, even if they are of age, if they're in their early 20s, we might not want a child to get $500,000 when they turn 21. So we start talking about ways to structure it. And so one of the things I always mention is, probably if you've got 2 kids, if you've got 3 kids, you probably love them the same, but you probably didn't treat them the same in terms of when they were growing up. Maybe you were a little bit more disciplined with one. Maybe one required a different type of discipline. Maybe one did more chore. You treated them differently in some way, and really the way you leave them the money might be the same as well. You might treat them a little bit differently. Typically, again, the majority of our clients, they're probably going to say, we just want our kids to get the money. And then we'll talk about putting the money in trust for them so that it's protected in the event that, they get divorced, so that the son-in-law, the daughter-in-law can't walk away with the money. Or maybe if they're in a risky business or, susceptible to get rich quick schemes or something like that, we can protect it so it's not subject to creditors or anything like that. And that's typical, right? Because they still have access to the money. They can still take out the money if they need it, but it builds in a lot of protection for them. And most of our clients, for a lot of the clients we have, that's the way it's going to be set up. But then we can set it up a little bit more restrictive, where if we're concerned about, maybe they've got alcohol, drug problems, gambling problems, something like that, we can protect them from themselves, where we name an independent trustee, someone else who's going to be in charge of their money, someone else who, that child can't just go withdraw money from the ATM. They got to go to this person or this bank or this trust company. So there's a little bit more of a buffer. And that, again, the kids might not both need that. This is where we talk about kids being different and just needing potentially different requirements. And then if we've got a child who has special needs, we want to make sure that their benefits are protected if they're receiving any sort of government benefits, because if they get, a large amount of money, that's going to cause their government benefits to be eliminated, which would be catastrophic for most people with special needs. So again, there's a lot of different things that you can do. It really depends on the child, but it's just something that you want to work through, something you want to think about when you're planning about distribution. I think the worst thing you can do, really regardless of the amount, is just say, hey, let them get it. When we pass away, they'll know what to do with it. Even if that's the case, set them up for success, set them up with some very simple things. It's not very difficult. It doesn't take a lot of work on your end or on their end, but the benefits are so great. Again, I think just for divorce protection is huge, especially if they are already married and they never got a prenuptial agreement, or against, maybe they would get a prenuptial agreement, who knows? So there's some great things that you can do to set that up. So again, when you're doing your estate planning, don't think equal in terms of how they get the money. It might be equal in terms of the amounts they're getting, but how they get it might be different.